Hello, John Miller, Rock Solid Law, founding attorney, and welcome back. We so appreciate you guys joining us, some of you regularly, and maybe some of you for the first time. Any of you that are here for the first time, we certainly welcome you. Elise, Heather, Malu, I think I already said good morning to Sue. So many times I am addressing interesting subjects, or we find them interesting, in estate planning. And in fact, the one on August 13th will be the full estate planning discussion overview, and that will be an hour session. We're going to offer it twice, 9 a.m. and 5 p.m. We think that one is so important. Today, I'd like to talk about one of my very, very favorite subjects, and that is closing real estate. You know, in 1991, I opened my solo practice then and my independent practice now in Ponte Vedra. And since that time, I've been in Ponte Vedra, Atlantic Beach, and now Jacksonville Beach, which is closer to my home, right near the end of JTB. And in all that time, I have really enjoyed closing real estate. Those of you that know my history know I was a litigator. I was a trial lawyer. I did business trials, which is pretty exciting and very stressful. And I found after about, let's say 10 years in my practice, which is now 35 years, that I really like resolving issues, getting people to the table, and helping people make deals and close transactions much more than I like fighting over the crumbs when a deal has gone bad. So I still represent business clients, trying to put them in the best deals possible. But a big part of our practice now is the real estate closing practice, and it has been since 1991 when I began it. I truly enjoy closings because when done right, it can be a win-win proposition for everyone involved. It allows someone to move to the next phase of their life, hopefully with a pocket or bank account full of money, and somebody else to have the keys to a new home or investment property and move toward their goals. You know, we call them closing celebrations here at Rock Solid Law. I think a closing should be a celebration. And I think it should be that by the time we get to the table, every issue that has existed between the parties has been addressed and ironed out. This morning, we're going to look under the hood, if you will, a little bit at the closing process from my perspective. John, what's your perspective? Well, I'm an attorney, as you know, and I am also a title agent and serve in several other roles as a part of the closing. So I will fill you in more on that, but my perspective is from the side of providing good title, of taking care of the parties, the realtors, the lenders, and everyone else, all the other vendors that are involved in the process. So my title today was What Really Goes On and Why Did It Happen There? I thought those would be a couple of interesting questions for people. So closings, we just use the word closing. What are we really talking about? Typically, it is to deal with real property. It can be raw land. It can be a residential. It can be a commercial. It can be a cash deal. It can be a deal with the lender involved. It can be a deal where the seller takes back, we call it taking back paper, essentially making a loan to the buyer to enable the buyer to purchase that property. It can be a refinance with rates at historical lows now. We are seeing a lot of refinance business. I think I mentioned commercial. Of course, it can be a business transaction as well. And commercial transactions are really their own special sort of animal and are quite different from a residential closing in many cases. Some of the smaller commercial deals are not much different than the residential. So in order to get to the closing table, the attorney performs or has performed a review of the chain of title, and he's got to review that report on the status of the chain of title, and he or she will then clear all impediments to title, because that seller wants to transfer to the buyer, and the buyer certainly wants to receive title that is clear of any infringements. What might an infringement be? Well, there are a lot of them. A lot of people have mortgages that have to be cleared. Of course, there are other liens. Maybe somebody didn't mow the grass and the city had to do it, filed a lien. In many cases, people have had work done on their homes, like a roof or other repairs, and a notice of commencement is filed and never terminated, even though they were properly paid. The law firm will go around and find those people and get all the documents properly executed and recorded so that by the time it gets to the closing table, there are no outstanding liens against the property. Another one, we'll have a survey, and another one might be maybe there's encroachment. Maybe somebody next door built a shed over the property line. Yep, I've had that one. Maybe the owner built their pool into an easement. I've had that one. There are all sorts of different things, and you just never know until you review that title commitment, that chain of title review, so that you can determine what needs to be done prior to closing. We call that transferring good and marketable or fee simple title. All you really need to think about is it needs to be clear, right? We want clear title. We don't want clouded title. We want clear title. We love a clear sunrise on a beautiful, actually the clouds were beautiful at sunrise on Jacksonville Beach this morning, but we like a beautiful clear sky over the property that we transfer. So we want clear title. Up to the closing, the attorney or title agent has been working with realtors, if there are any in the transaction, and there usually are, loan officers, the parties themselves typically, and any number of vendors that are involved in a particular transaction. A surveyor may be one, there may be a home inspector, there may be somebody that's done repairs. There's just all sorts of different vendors. Of course, you have to communicate when there is a PUD or a homeowners or condo association. You've got to communicate with the management company typically to make sure that all of the covenants and restrictions have been complied with and that all assessments have been paid, right? So behind that curtain, I like to imagine the Wizard of Oz, back there pulling all those strings. Behind that curtain, we want you to ignore that man while he's frantically getting everything done, but we want the party to experience a very smooth transaction getting into the closing room, having had all of these things come together to get the title ready to go and to allow us to create literally a small book of documents for each closing. They're usually about an inch, sometimes close to 2 thick. Some transactions we're getting a little less paper on, and they could be as few as 40 or 50 pages. As someone who's done it 30 years, when I started out, it was a very few number of papers that we needed for a closing, but over time there have been a lot of things that have crept into title and closing that have caused more documents. You can think that every document other than the super salient central documents to the file have been created because of a lawsuit at some point in time. Somebody sued somebody over something, and we've got a document that has to be signed by every participant in every closing to make sure that no frivolous suit is signed because someone later claims, for instance, that the tax documents that they provided to their lender were not supposed to be used in considering and giving them a loan. I think you can read my opinion into suits like that through the lines. So small books worth of documents. How did the closing get to that law office or title company in the first place? The person who is paying for the title insurance policy gets to pick. Okay, Florida's a really interesting state to me in this regard because in different parts of the state, traditionally, as here in Northeast Florida, the seller pays for title. In other parts of the state, the buyer pays for the title. That also comes with the choice of where to order the title, which underwriter will provide title, and where to close. So whoever pays for title gets to pick. In Northeast Florida, if a buyer really wants to pick their closing attorney bad enough, they can offer to pay for title. Now, I will tell you on the commercial side, the buyer more often does that than residential. By and large, we are blessed in the real estate community in Jacksonville, Ponte Vedra, Northeast Florida, to have very high quality closing attorneys, and even some non-attorney title companies that provide quality services. I will just have my usual rant and tangent at this point in time that I highly recommend above all other things that you use a title company who has an attorney on board, because we attorneys are trained in the law of real property and will make sure that transaction goes smoothly. After the run up to the bubble in the early part of the aughts, the first decade of this century, and after what went on in the 90s, we had the opportunity to perform a lot of free work to fix titles that had been prepared by fly-by-night title companies. So they're out there. Just be careful. Use a quality company. I've practiced a long time. We're not the only quality company out there. When I know one of my friends is working with someone with a good reputation, I'll tell them so. There are a few title companies that if someone asks me privately for my professional opinion, I will share that with them as well. There's some that are doing practices that I absolutely don't approve of, we will not do, and in my opinion, are illegal. I'm talking about double closing flips. They're calling them warehouse loans now, where there is no money into the first loan until the money that comes out of the second closing. And folks, that's illegal. So if you're running across people that are doing that, report them and run away. That is my highest recommendation. People ask me for a referral to those companies that do that, and I will not give it to you because I think that damages the entire real estate industry. And I'm off my soapbox now. So often the seller who's paying for the title insurance policy, who has therefore the choice of where to close, doesn't know a title attorney, and therefore leaves the choice up to their realtor. So the realtor who has listed the property is often the person who is choosing where the closing takes place. I'd like to think that those of us that have been in the field a long time and strive for excellence in providing our services are the ones who get chosen more often by the realtors, who are also, of course, real estate professionals and know where the closings are good, reputable, professional, and we'd also like to think with a touch of fun take place, and therefore are funneling more closings to those places, to those companies. But though often people will rely on their realtor, it is absolutely the party's choice. And sometimes there is a seller who has a relationship with an attorney and wants to close in that office because they have good faith and confidence in them. I've been on both sides of that. I've had people that, probably more often people that I have known who have sort of overrode their realtor's choice and asked to close with us. There have been some other times when a realtor wanted us to close, but a particular seller had somebody else in mind they wanted to work with. And, we just believe that there's an abundant universe out there. There's plenty of work for everybody that's providing quality services. Of course, we want them all, but we know if we had them all, we probably couldn't handle them all. So we want other quality providers out there to receive their share. And we want to perform our share of services as well. So we know how that system works. It's no big secret. And sometimes we don't get closings we wish we would get. In some instances, the real estate brokerage will own a title company, and typically the realtors that work for that company are encouraged to close with the title company that is owned or affiliated by them. Other realtors prefer to use an independent like us. I've been an independently practicing attorney since 1991, and we treat everybody evenly who comes to us for services. So the sellers, one of the most important people at the closing table, right? So what are they there for? Their interest in the closing is to get all the documents executed they have to, typically as quickly as possible, and to receive their proceeds, the proper amount of their proceeds, typically as quickly as possible, and then go along with their life. That's what the seller wants to do. The seller wants you to take care of whatever the needs are on their property, tell them what to do to clear the lien from that window contractor that didn't close the notice of commencement, and give them their money and happily send them on their way. The buyers, The buyer's interest is to receive all that they have bargained for. And often they'll ask for things that we've actually taken care of, and we'll just point out to them how we did that because they didn't understand that it just happened behind that magic curtain. What they really want is a smooth transaction with as little stress as possible, and they want the keys to that new house, right? They also want a free and clear title that has been provided to them, and they're going to want to receive the title insurance policy, which means that the underwriter will defend their right to own free and clear title to that property against the whole world. The realtor's interest is to be sure that the contract that they have brought together is closed properly, that their commission checks are dispersed properly, and often in non-pandemic times, realtors attend closings. I will tell you that before mid-March, we regularly had 8, 10, sometimes 12 people in our closing room. It's a party, and we try to approach it that way professionally, but we try to let the fun happen. And typically realtors were attending closings then. I expect to see them more again in the future. But in the present time, many of the brokers have, I think responsibly, asked the realtors not to attend the closing. I know that's hard because like us, we want to have ongoing relationships with our customers and clients. And the realtor wants to be there at the moment the high fives happen, right? When you've completed the transaction, when everything's gone perfectly and everybody moves on. So I have to also say, I enjoy most of the realtors we work with, and I miss them. We don't get to see you guys as much now, and look forward to having you back in our office soon. So the lender's interest. The lender's interest at the closing is to be sure that they are in a first mortgage position, having collateralized the repayment of the loan they're making. That means that in addition to the note under which the buyer borrows the money, a mortgage is properly executed and will be subsequently recorded, which is a lien against the property until that note is paid back in full. As long as the buyers pay in accordance with the payment plan, the amortization provided to them as a result of their note, the mortgage really means nothing. Should they fail to pay, then the mortgage means that the lender can look to the home for the repayment of the loan. So the lender wants all of the documentation that they provided to us to be properly executed and then properly returned. So the bank relies on the lawyer to make sure that the documents are executed and the loan is secured. The attorney actually has a fiduciary responsibility to the lender to make sure that the lien is perfected in exchange for the lender providing the money for the buyer to purchase the property. The bank is also interested in making sure that all of its fees are properly paid and all of the escrows are properly deposited. Under most loans, the parties will escrow for such things as taxes and insurance, right? So the bank collects an amount above the minimum principal and interest and keeps it in a special segregated account so that when taxes come due and insurance comes due, they can pay it. Sometimes, again in non-pandemic times, loan officers attend the closings. We always welcome them, and I tell you why. They will know their loan product better than I ever can. And should there be specific questions from the borrower about the loan product, they will be able to answer that question right there at the table. So we love having the loan officers who like to attend. We know that many of them have been told not to, and this time that's going to happen in my conference room today, in fact. A loan officer I would usually really look forward to seeing, I've done it for years, is not going to be here. So in addition to having a fiduciary duty to properly close the loan, the attorney may be representing one of the parties and is likely acting as escrow agent, meaning the attorney must account for receiving all the funds of the transaction and disbursing them properly as required. You know, you hear closing, title, and escrow. Escrow is one of the really important parts. Escrow must be kept in a proper account, and that account must be reconciled perfectly so that every penny is accounted for. So closing, title, and escrow. Now, sometimes there is an additional escrow agreement for the parties for such a thing as repairs. Had one recently where a roof needed to be fixed. So we entered an additional escrow agreement with the parties where a certain amount of money was held out until the repair had occurred. That's a different escrow than the one that we're talking about. Unfortunately, in the law, as you've discovered if you've been with me for a while on these Zooms, often the same term will mean a couple of different things. So let's see. A fourth role played by the attorney is that of the title insurance agent. The attorney is the point of contact for assuring that all liens are cleared, we talked about that, from the property, and that the policy of title insurance, or policies, I apologize, of title insurance are properly issued to the new owner, certainly, and to the lender if there's one involved. So a quick aside, the seller typically purchases a policy of title insurance for the owner. That policy of title insurance will be in effect as long as the owner owns that property and will defend the owner basically against all the world. At the closing, if the buyer is a borrower and takes a loan, the buyer will purchase at a discounted rate a policy of title insurance in favor of their lender. Excuse me. Finally, the first day of baseball season is here, and my baseball ties seem to have put a little cough in my throat. The buyer will purchase a policy of title insurance in favor of their lender. That policy will be in effect as long as the loan is in effect. If they refinance and take another loan, they will need to buy another policy in favor of the next lender. Okay, so, or if they pay it off, that policy's done its job and it goes away. If you've ever wondered why the closing fee charged by an attorney is so small for a real estate transaction, actually less than 1 hour of my billable time, it's because part of the remuneration comes through sharing in the title insurance premium. It's earned as the agent of the underwriter of the title insurance company. This arrangement allows the business plan for the real estate attorney to function, because candidly, the fee we charge for a closing would be less than the overhead we have put into getting your closing to the table with staffing and costs and everything else. So no mystery there. I think most people in the industry know that's how it works, and wanted to share that with people that are just interested in real estate. And additional role supplied by the attorney is to explain the legal import of each of the documents being signed and to answer questions that the buyers and sellers might have about the obligations they're undertaking by signing the documents. In my opinion, it's really important that there either be an attorney at the table or available during the closing to explain what the contracts that are being executed mean, what the obligations the parties are undertaking entail, and so that those parties leave that front door fully confident of what they have just done, what obligations they have undertaken, and what rights they now have. So when the entire system is functioning correctly, the parties are already aware of all of the facts and figures about the closing before they arrive at the closing. Therefore, in most instances, there are few, if any, remaining questions about the mathematics of the transaction. Granted, math not totally my strongest suit either, so I might have had a question or two. Typically, when there are questions about that, somebody just doesn't understand the closing disclosure or the settlement sheet, the settlement statement, so that when you walk them through the math, there'll be an aha moment. However, mistakes do occur. Humans are involved in this process. All humans are fallible. And if there is a question, we welcome it. And if you have a question in a transaction anywhere, you should ask it. The only bad question is the one not asked. So I would highly recommend any questions, even if you're afraid you might be wrong. Don't worry about the embarrassment. Nobody else knows this stuff either, except the professional sitting in the room with you that can help you. Often, candidly, often the loan officer, often the realtors will be able to answer the questions equally well as the attorney. And if all three of them are in the room, you have good professional help. And next line. We always say the only bad question is an unasked question. Particularly, we want the first-time home buyer and every home buyer to leave our office with no questions left unanswered. So quickly, I know I'm going a little long this morning. Quickly, I believe that home ownership is the cornerstone of the American dream. We are the first country in the world that allowed private citizens to own our homes. And I think that every person born to or coming to this country has the right, and I hope for all other citizens, to own their home, because it is truly an American adventure. It was in our Constitution. It was the first time anywhere for those of us that are European descended. We all worked for the Lord of the Manor. Here in America, we wanted everybody to be able to own their own land. That's why I call it the cornerstone of the American dream, the real foundation and building block of the totality of the American dream. And I always like to point out that who wrote that into the Constitution? 3, 2, 1, the attorneys. So thank you very much, my brethren at the bar from the 1770s took care of that for all of us. And I like to celebrate that. I think that is worth celebrating. The first-time home buyer is one of my favorite things to ever get. And when people are buying on their way up, when they're improving their lives by moving to a different neighborhood, by buying a bigger house, by expanding their family and needing more room, or on the other side, when they have been successful and now they're downsizing. So, after the closing, what gets distributed and to whom? Each of the parties is going to have the documents, either or both of electronically or in paper at their preference. And we're going to make sure that all the checks go to all the parties who need it. We're going to make sure that the new buyer who now owns the home has their keys. And we're going to make sure that all the documents go back to the lender that need to go back to the lender, that go to the courthouse to be recorded, that need to go to the courthouse to be recorded. And we're going to follow up until all of those things are done. For you buyers, new owners, you need to watch your mailbox over the next month to 6 weeks to look out for your title insurance policy. And you want to take that policy and put it in a very safe place, perhaps with the rest of your closing documents if you have an actual physical file. I also highly recommend taking that deed when it comes back from being recorded and putting it in a fireproof safe or other very safe place, either in your home or perhaps even in a safe deposit box with a bank. At Rock Solid Law, when the parties are willing, we love to take a celebratory photograph at the end of the closing. We think it's a wonderful thing to celebrate those big occasions in our lives, and we think that transfers of real property typically are crossroads, big moments in our lives. We even do it when we have our masks on. It's kind of funny to see our pictures where we all have our masks on, but we are being as safe as we can during the outbreak of COVID. On a proper closing, when the parties want to do so, we will offer a small glass of champagne to celebrate. It's a nice touch that we enjoy. We typically do those in the afternoon closings, although I have had people that wanted to do it in late morning. I'm not able to join them then because I have to go back to work. Just so you know, we do offer a non-alcoholic sparkling grape juice for those who choose not to have the adult beverage. So that's kind of the end of my remarks. I know I've gone a little bit long this morning. I really appreciate you guys joining us. I would ask you this time, if you have questions, to please send them to questions@rocksolidlaw. And you ask, why am I cutting you off without a question and answer session like I do every time I do one of these? Because I have a closing and I have to get out of here, and I have to get those documents to the table. and help somebody to enjoy their new home. Thanks for tuning in, everybody. We're going to be back, like I said, I believe it's August 13th. We'll send out an email. And at that time, we'll be talking about estate planning and do the full overview of the estate planning process. Thank you all. Be safe, be healthy, live long and prosper.